Welcome to the debate. The fight over Alabama's congressional redistricting has just reached a fever pitch, with a federal court blocking the state's map as an intentional racial gerrymander, setting up an immediate, high-stakes showdown at the U.S. Supreme Court that could alter the balance of power in the 2026 midterms.
It is definitely heating up. Yeah.
Right, and before we dive into today's discussion, please take a quick moment to like, subscribe, follow, and turn on the notification bell so you never miss an exchange.
Absolutely. Please do that.
Also, just a quick update on the Martin Stevens versus OpenAI matter. Just to be absolutely clear here, this is still not a lawsuit.
Right. No lawsuit yet.
Exactly. We are currently in a voluntary quiet period at Stevens' request. And, while we certainly hope for a settlement, we don't have any inside knowledge on how those talks are going or, even if they're happening right now.
Yeah, we are completely in the dark on the specifics.
We are. Crucially, though, we want to confirm his dead man switch has not been activated, meaning Stevens is physically and legally safe.
Which is great news. But turning completely to the Alabama redistricting dispute.
Yeah, so a 3-judge federal panel just blocked Alabama's 2023 legislatively enacted congressional map, ordering the state to use a court-drawn special master plan for the 2026 elections. And, this has sparked intense outrage.
Oh, intense is an understatement.
Right. State Senator Marika Coleman called the special session, quote, some bullshit. Representative Napoleon Bracey called the map an all-out attack on the Black community, and Representative Jawanda Lynn Givon actually compared the maneuvering to a return to Jim Crow.
It's really heavy rhetoric.
It is. So our central question today is this. Did Alabama's 2023 map intentionally discriminate against Black voters? Or, was it a lawful exercise of partisan redistricting protected by recent Supreme Court precedent? I will argue that the map is a clear case of intentional racial discrimination that blatantly defies federal court orders.
And I will argue that the map is a lawful, partisan-driven effort to protect incumbents and keep communities whole, completely in line with our constitutional frameworks.
So let's look at what actually happened on the ground here. The Supreme Court affirmed an order in Allen v. Milligan for Alabama to create a second majority Black opportunity district.
Right. Basically a district where minority voters actually have the numerical majority to elect the candidate of their choice.
Exactly. But the state legislature just ignored that. Instead, they manufactured these novel redistricting guidelines, basically out of thin air, to ensure places like Selma and the broader Black Belt were fractured.
Well, I wouldn't say thin air, but go on.
They literally drew lines right through these communities, splitting them into majority white districts so that a second Black opportunity district became mathematically impossible. That is not normal politics. It is an intentional violation of the 14th Amendment and Section 2 of the Voting Rights Act.
See, I come at it from a completely different way. You're looking at lines on a map and assuming racial animus, but the lower court dangerously conflated race with raw, partisan map-making.
Dangerous how exactly?
Well, just look at the Supreme Court's recent Louisiana v. Cawley's decision. That ruling clarified that prioritizing partisan goals like maintaining a 6-1 Republican map and protecting your incumbents is legally permissible. Alabama was just utilizing traditional redistricting principles.
By splitting the Black Belt?
But refusing to split the Gulf Coast community of Mobile and Baldwin counties, right? Punishing a state for practicing lawful partisan politics, just because it heavily overlaps with racial demographics, really undermines the equal protection promise of the Constitution.
I hear what you're saying about partisan goals, but let's examine the actual trial record regarding the legislature's intent here. During that 2023 special session, they suddenly introduced these non-negotiable redistricting guidelines.
Right.
But when you look at the evidence from when the map was actually drafted, there's zero proof of partisan intent. The focus was entirely on race, specifically keeping the Black voting age population, or BVAP, of District 2 low enough to ensure a Black preferred candidate could never win.
Wait, let me push back on that.
Just let me finish this one thought. Creating unprecedented legislative guidelines right after losing a major Supreme Court battle is it's like changing the rules of a board game right before you're about to lose just to ensure your opponent can't win.
Yeah, but it is not changing the rules of the game. It is playing defense with the rules that already exist. I am sorry, but I just do not buy the premise that it was pure racial animus.
Even with the new guidelines.
Yes, even then. I mean, U.S. Solicitor General John Sauer actually filed a brief supporting Alabama, arguing that the state's insistence on pursuing partisan goals to protect its incumbents does not make those goals racially discriminatory.
I read that brief, yeah.
Right, so if a state's voting patterns are inherently polarized along racial lines, how can we legally condemn a legislature for making a purely partisan calculation to preserve a 6-1 Republican delegation? The motivation is political survival. It's not some deep-seated desire to disenfranchise based on race.
Okay, but even if we assume their intent was purely political survival, we have to look at how the Supreme Court's newest rules actually govern that behavior, which brings us right to the Calaf case you mentioned.
Yeah, a very crucial precedent.
Right, because even with those political motivations, the district court found the 2023 plan was still tainted by intentional race-based discrimination.
Except Calais is exactly what prohibits federal courts from forcing states to draw racially gerrymandered maps just to satisfy Section 2 of the Voting Rights Act.
Wait, forcing?
Yes, forcing. By forcing Alabama to use a 5-2 map, one that actually ousted a Republican incumbent in 2024, by the way, the district court is demanding the exact race-based sorting the Supreme Court just outlawed. The lower court is basically demanding proportional representation through racial gerrymandering.
That is an interesting point, though I would frame it differently. Because Calais explicitly did not overrule Allen v. Milligan, the very case that originally found Alabama guilty of vote dilution in the first place.
That's true. It didn't overrule it.
Right. And furthermore, if you look at the court-ordered special master plan, it was actually designed to be race-blind.
Race-blind, really?
Yes, exactly. The special master achieved a compliant map using traditional redistricting criteria without prioritizing race. It proves that it is entirely possible to cure vote dilution without unconstitutional racial gerrymandering. They didn't need race-based sorting to fix the map.
Okay, that is a compelling argument. But have you considered the immediate, on-the-ground reality of the looming August 11 special primary elections? Because beyond the theoretical legal doctrines, we have an actual election administration crisis here.
You were talking about the Purcell principle.
Exactly. Injecting a map change months before an election violates the Purcell principle. For our listeners, that is the legal doctrine warning courts against late-stage judicial interference in election rules simply because it creates chaos.
Chaos is a strong word.
But accurate. Attorney General Steve Marshall warned this will cause massive voter confusion and severely strain election offices that are already, preparing for candidate qualifying and ballot printing.
Yeah, I hear that, but I'm just not convinced by that line of reasoning because it completely ignores the factual testimony of Alabama's own director of elections, Jeff Elrode.
What did he say?
Well, he pointed out that voters are already assigned to the special master plan in the state's computer systems. It was used in 2024, and it is queued up for the May 2026 primary.
So the systems are already set.
Yes, exactly. Reverting back to the 2023 map right now would require a chaotic, Herculean reassignment effort. The court-ordered map isn't a disruption. It is the practical status quo. And joining the 2023 map actually prevents administrative chaos.
But look, even if the computer systems are currently loaded with the special master plan, the legal status quo reverted to the 2023 map the very moment the Supreme Court vacated the lower court's permanent injunction.
Legal versus practical, right?
Right. And a state has a fundamental sovereign interest in conducting elections under its duly enacted laws, not some map forced upon it by a federal panel.
Well, when we step back and look at the totality of the evidence here, it overwhelmingly points to a legislature intentionally diluting minority voting power in clear defiance of federal orders. The record shows they manufactured rules to mask an unconstitutional objective.
And from my perspective, Alabama is being unfairly penalized for standard partisan map making, which is a practice validated by the highest court in the land. They're being pushed into race-based sorting that defies recent Supreme Court guidance.
Yeah. I think we both agree, though, that the Supreme Court's impending decision on this emergency stay will be deeply consequential for how the Voting Rights Act is applied nationwide.
Oh, we absolutely agree there. The stakes are massive. It is clear we have a fundamental disagreement on exactly where the line between lawful partisan gerrymandering and unconstitutional racial discrimination lies, especially, in regions where voting habits are deeply racially polarized.
Absolutely. The complexity of untangling race from politics in the South is profound. And as we watch this legal battle unfold, we really have to ask ourselves, when the rules of the board game are changed at the final hour, does it matter if the goal was just to win, or does the way you alter the board reveal a deeper prejudice?
A very tough question to answer.
It is. Thank you all for joining us for this exchange. Please remember one last time to like, subscribe, follow, and hit the notification bell so you can stay updated on all our future debates. See you next time.